We'd like to acknowledge that we are presenting this session on Treaty 1 territory where the Occupational Health Center is located, the traditional territory of the Anishinaabe, Cree, Oji Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. Occupational Health Center acknowledges that we are all treaty people, and we recognize the history and the impacts of colonization on Indigenous peoples. We commit ourselves to active accountability, to justice, to equity, and reconciliation. And for folks in the audience who aren't aware of who we are, the MFL Occupational Health Center was established in 1983 to meet the need for quality, accessible, and comprehensive services on workplace health and safety. And that need continues today. So we help workers, employers, and join health and safety committees to improve workplace health and safety conditions and eliminate hazards. Our services are available, they're free of charge, so please check out our website and what we have to offer at ohcmb.ca. And for today's presentation, we will be recording and posting the presentation on our website, probably within the week. And for questions, please put your questions in the chat for David. And Jeff and I will keep track of them and we'll ask them of David at the end of the presentation. And if there are a lot of questions, we do have a little bit of time after 10 o'clock as well to stay on if there's a lot of discussion. And with that, I will hand it over to David. So welcome, David. I'll just stop sharing here.
Thank you very much, and thank you for inviting me. I'm just going to try and share my screen here. See that this works. Can you see?
Yeah, it looks great, David.
Bright blue PowerPoint, lovely. And see if it actually works as well. Not getting it to advance any slides, unfortunately.
Okay. So even
try this one here instead.
So if you go to, slide.
There we go.
There you go.
Different screen. We're good now.
Okay.
Thank you.
No problem.
Always a technological issue or a user issue, one way or the other. So thanks for joining this morning to learn a little bit about the workers' compensation appeal process. As indicated, I'm the workers' compensation specialist for the MGEU, and I've been doing WCB appeals for close to 18 years now. So I have a little bit of experience in the matter, I would say. And just in terms of a little bit of a background, I wanted to focus on, I always talk about the historical compromise that is the WCB. Workers gave up the right to sue their employers in exchange for a guarantee of benefits. Now, we're not talking about a guarantee individually, but a guarantee systemically. So whether or not an employer is continuing on or goes bankrupt or whatever else the case may be, a worker has the right to access the compensation system through this historical compromise. So I think everybody probably knows already that it's an insurance system that provides compensation, wage loss, and medical benefits primarily to injured workers or to workers who suffer injuries at work. And it's important to realize and important to know, because it is important for the appeal process, that the entire system is funded by employers. The legal framework that's established, and I'll speak a little bit to that as well, is established by the provincial government. And each provincial government, Manitoba, Saskatchewan, Ontario, and the like, all separate and establish their own legislation. So the appeal process that we're going to be talking about today is specific to Manitoba. The appeal processes in other provinces and other jurisdictions will differ, so we can't really speak to any of those. So the legal framework, as I'm referring to, starts out with the Workers' Compensation Act. And the first act was actually passed by the Manitoba legislature back in 1916, and the Workers' Compensation Board was established in 1917, so well over 100 years ago already. And the act that's in play at the time of your injury is the act that will apply for the duration of your claim. So it stays with you. If you're injured in 1992, the act that was in play at that time is going to continue to apply to your claim indefinitely. And there is provisions that the legislation changes and is reviewed every 10 years or so. And so there are changes incrementally over the course of time in terms of what benefits are allowed, what sort of accidents are accepted, and the like. So that kind of sets out the large parameters of how the workers' compensation system operates. Below that are regulations, also established by the government, that further provide defined provisions of the Act. Neither of those are generally too terribly controversial in terms of appeals. They do speak to the appeal process, but they're not giving kind of the details that the policies do. And so it's the Workers' Compensation Board of Directors that establish the different policies that clarify both the interpretation of the Act and regulations. They're very specific, and it's the board that can change them. Those policies can be changed by a board order at any time. So a policy that applies today may not apply tomorrow if the board of directors sees fit to change it. In all, I believe there's just over 103 policies, many of which apply to the compensation program in terms of how benefits are supposed to be administered. I've also referenced here WCB internal position statements in quotes because that's how they refer to them. They're kind of like policies, but whereas the WCB policy manual is available online for all the public to see, these position statements tell staff on how they're supposed to be looking at different issues. A couple examples are concussions and myofascial pain, low back pain. The WCB has position statements that dictate how those claims are supposed to be looked at. And frankly, you won't know that a position statement is being used in the management of a claim unless you know that it exists. And frankly, most injured workers aren't going to know that. So it's a little bit of inside sport that you're not necessarily going to be aware of unless you specifically ask about it. So policy 2010 reconsiderations is what speaks to how an injured worker or an employer for that matter can appeal a decision on their claim. And so I put a couple of points here in terms of reconsideration or appeal. The WCB uses reconsider in lieu of the word appeal. We like to use the word appeal because that's what we're doing. But it's decisions that impact a worker's entitlement to benefits. It's not a kind of an abstract thing. Quite often, injured workers come to us saying, well, the WCB has decided that I've recovered and I don't agree, and so I want to appeal that decision. Well, in actual fact, the suggestion that you've recovered from an injury may be the reason, but the issue that you're going to be appealing is entitlement to benefit. So the WCB may have terminated wage loss or medical benefits on the basis of they believe that you've recovered. So the rationale is recovery, but the issue that we're looking at is entitlement to wage loss or entitlement to medical benefits. That's what really needs to be focused on. You can't appeal procedural issues or administrative issues, irrelevant things that are really kind of how the WCB does business. Those aren't something that's subject to appeal. It's really a worker's entitlement that they focus on. And who can request reconsideration? Both workers and employers can request reconsideration of any decision on a worker's claim. As I said earlier, workers and employers are party to the claim. So while generally speaking, over the course of a claim management, employers don't really get to know a whole lot about the claim aside from kind of the prognosis for recovery, any sort of restrictions if you're attempting to return to work. But that certainly does change when they're accessing the claim information for the purposes of appeal. And so employers, just as workers, have the right to appeal under the reconsiderations policy. I would say that the vast majority of appeals are done by injured workers. In my experience, probably out of 100 worker appeals, there'd be 1 or 2 employer appeals that are generally about the same issues, although there are specific issues that employers can appeal as well, such as assessments, penalties, cost relief if there's a pre-existing condition that's impacting the claim. And I have a little asterisk there at the bottom to indicate and to make it very clear. It's not a reconsideration, but the WCB has the right under the Act to change and review any decision on a worker's claim at any time. So it's a very important thing to understand. Quite often we'll have workers coming to us saying, well, you know what, my case manager told me this, and now they're doing this. They've changed their mind. Or they've decided to do this, and now they've about-faced, and now they're doing this. It's not fair. Well, in actual fact, the Workers' Compensation Board has the right to change its mind based on information coming in that may have differed from previous information or simply just a perspective. So it's something to keep in mind that workers' compensation claims are very active. They're living and they change over the course of time. So the reconsiderations policy outlines a few steps in terms of how to appeal. And interestingly enough, they call, or I'll call it, a pre-appeal. The first step is actually to discuss the decision with your adjudicator or case manager. And the reason in the policy is to understand the reasons. What is the basis for that decision? Why is the WCB denying benefits or denying a claim? There's supposed to be a meeting of minds so people understand why this has been done. And through that conversation, the other intent is to ensure that the decision maker has all relevant information. So quite often there'll be a conversation that will say, for instance, yeah, I was hurt and I'm being treated for a back injury, but my doctor has requested an MRI and I'm going to be having that in a couple of weeks. Well, that's relevant information that the WCB needs to have in order to make a fair decision. So through this discussion, if it wasn't already known, then the decision maker is going to become aware of that. So this first step may result in further investigation. In my experience, it quite often is the reason why I will be going back to a case manager or adjudicator after review of a file and after conversation with a worker. It seems that the WCB has missed some very important information. And so my point or my purpose is going back to the adjudicator is to ensure that they've done a proper and thorough investigation to cover all the bases, ensure they have all the information, because it's really important to kind of get the information on the table as early as possible in the process. Unfortunately, there is no timelines constraining this first step. So if you ask your adjudicator to get some more information, you're really at the mercy of that timeline. So if you ask them to get an MRI report from your doctor and your doctor doesn't comply quickly, you could be waiting for weeks for that reconsideration process to occur. There's nothing that puts that timeline in a fast place. Sometimes a conversation will be very quick and the adjudicator case manager will say, yeah, I understand, and I don't think that information is relevant. I don't want to get that information, and that's that. My decision stands. At least we have that opportunity to have the conversation. Sometimes that new information does cause the decision to be changed or reversed. One point that I did want to make, though, is that quite often in terms of the process, it's a little bit of a strategy. Sometimes we want the WCB to do further investigation because they are failing to get all the information that they need. But on other cases, frankly, the case manager, the adjudicator have the decision so wrong that we don't necessarily want to point out their flaws, because it will actually give them an opportunity to sort of cross their T's and dot their I's and firm up their decision so that it's much harder to appeal. So in some cases, strategically, we won't really pursue this sort of informal appeal process because it may actually impact the claim going forward. The other thing that we need to know at this first step is a written decision is actually required to proceed with an appeal. Sometimes case managers or adjudicators will kind of explain things or talk about what they see happening. Like, I expect that your benefits will end soon because we expect that you're going to go back to work. Well, that's not a decision. That's just a conversation about what to expect, what's going to be happening, right? But once they've actually formalized that decision, they've put it in writing, they've provided a rationale, then we can proceed with the appeal process. And I just wanted to point out that there are a number of kind of issues in terms of how a WCB decision is made. And certainly I appreciate that probably many of the people who are watching this webinar this morning have had negative decisions from the WCB. And if you have, or if you're dealing with one in your workplace, it'll have a list of kind of what's happened over the course of the claim. It'll have a laundry list or a history of things that aren't necessarily really relevant. It'll also speak to legislation and policy that may not be particularly relevant. And it will emphasize the information that they're relying on in making that decision. But what you won't see necessarily is any sort of way or addressing the information that actually supports the worker's position. So it's a very slanted or for lack of a better word, biased piece of paper, because it points to why the WSP is doing it, but it won't necessarily explain why you're wrong in your perspective. So the first formal level of appeal is called the WSP's review office, and so the WSP's policy says that every appeal needs to be provided in writing, and they actually have a request for reconsideration form online that stipulates what you need to provide in order to trigger an appeal. The worker's name, the claim number, the date of the decision, and the issue, in quotes, I put it in quotes, the issue in dispute, and the reasons for disagreement. So in terms of what the issue is, I suggested this before. Injured workers may want to appeal that WSP's decision that they've recovered. Well, that's not really the issue as the WSP sees it. The issue will be entitlement to wage loss benefits beyond a certain date. Now, for most injured workers who are appealing their own claims, they're not necessarily going to have a whole lot of understanding of what the issue might be, but it's the WSP's review office who will clarify that issue and to ensure that the proper things are being looked at when the file is being reviewed. So in terms of the process, kind of step walking through it, an injured worker or an employer will email or write or fax to the review office saying, I want to appeal this decision, and these are the reasons why. And the first thing that happens is the review office acknowledges that appeal by letter. And that letter will say, we've received your appeal, it's being assigned to this individual to look at, and it will take roughly 8 weeks. That's what the letter says. In general terms. But what happens is the review office will actually do a little bit of a screening. So they'll look at the file initially and just make sure there's a decision there, ensure nothing else is going on that needs to be considered before the appeal is actually looked at. But the review office actually can, and I would say in about 10% of cases, refer a claim back to the case manager and adjudicator if they consider the appeal to be premature. So what does that mean? It means sometimes they'll look at the file and say, well, a decision's been made, but there's new medical on the file that hasn't been considered. So what we're going to do is refer your claim back to the adjudicator or the case manager and say, you need to look at this new medical, see if it addresses the issue that's under appeal and if it warrants a new decision. Sometimes injured workers will provide new information along with their appeal, and the review office will kick it back to the adjudicator for that new information to be considered, because they won't look at new information, generally speaking. Sometimes the WSP, because frankly, there's timelines associated with making decisions and having claims adjudicated, they'll make a decision, but they'll continue to review incoming information. So the review office may say, well, we appreciate that a decision's been made, but the adjudicator is still reviewing this issue. And until such time that they've actually made kind of a concrete or final decision, we're not going to look at your appeal. So sometimes you don't have a decision, you don't have a choice of that matter, right? If the review office decides it's premature and they're going to refer it back, you have to wait for a new decision. In my experience, that could take a couple of days, or it could take several months for that new investigation or review to take place. All the while, the initial decision stands. So if benefits have been terminated as of a certain date, they will continue to be terminated until such time there's a reversal. So if the claim gets referred back for further review, you're not being paid during that time, unfortunately. So those are the kind of the two options. Either they acknowledge the appeal and say, yeah, we're going to work on it, or no, you're going to have to get your case manager to get a new decision, and then you wait for that. That letter will also go to the employer, and it really depends on who the employer is, the size of the employer. All the employers that I deal with at the MGEU either have full-time staff or paid consultants that represent the employer in workers' appeals. So I would say 99% of the appeals that I'm involved in, the employer asks for a copy of the claim file in order to respond to our appeal. It's a very controversial process because the employer has access to almost unfettered medical information on a worker's file. There is a process by which you can ask for any sort of irrelevant information to be redacted from the file before it goes to the employer. But if it's considered relevant to the claim, the employer gets to see it, and they'll generally respond to that appeal in an unfavorable way. In my experience, quite often workers will say, you know what, I have a good rapport with my employer, my supervisor and I get along. There's no way that they're going to oppose my appeal. I get along with my employer. But because it's independent, because it's people in a different office or a different workplace doing that as their job, most injured workers find it quite unsettling to find out that now they're not only disputing their WCB claim, they're also now fighting with the employer. It's quite an adversarial process in the end. Another thing that the review office may do is, after screening that file, they may decide that further information is needed for them to make a decision. And I would say most often what they do, if that's the case, is getting a medical opinion. So if a decision has been made based on some medical information that's on the file, but there hasn't been necessarily a review done by a consultant that works for the WCB, the review office can go and ask that medical consultant to take a look at the file and to offer an opinion. So some further investigation may occur through an appeal as well. And further to that, the review office also, as I said before, the WCB has the discretion to change any decision it made over the course of a claim. The review office has the authority to review any decision on a file, and they have the authority to expand what issues are under appeal. As an example, I had an injured worker who was a truck driver and had an accepted claim for noise-induced hearing loss that affected only his left ear. And the claim had been accepted on the basis that driving on the highway with the window rolled down caused excess wind noise, which caused his hearing to be impaired in the left ear. In subsequent years, he also needed a hearing aid in his right ear. And that was denied by the WCB on the basis of that hearing loss wasn't attributable to his work. Well, when he appealed to the review officer looked at the information and said, you know what, I don't think that you should be getting that right ear hearing aid, but I also don't believe that the left ear hearing loss was attributable to noise either. And so we're going to be expanding the issues that are under appeal. We're going to be looking at both the entitlement to a second hearing aid, but acceptance of the noise-induced hearing loss claim as well. So there is an element of risk in pursuing an appeal because the review office does have that option to expand issues once the claim is under its review. It doesn't happen often, but I do issue it as a caution that it can happen, and it does not infrequently happen. So any sort of new information, if the issue is expanded or if the employer provides some arguments in terms of the appeal, opposing the appeal, or if the review office gets a medical opinion, any new information that's produced over the course of that appeal process is presented back to the worker to review and to comment on. That's part of the natural justice process involved in the review office appeal. The challenge is, though, is when an injured worker is responding to an employer's argument and the employer knows the policies through and through, it's very difficult to craft a persuasive argument against that. Or if a medical opinion is provided from a WCB's medical advisor, most injured workers don't really have the capacity to look at that medical opinion and provide any sort of insight of why it might be right or wrong. So these are challenging things that may happen in the review process with the review office. But it's completely a file review. So more often than not, it's strictly done in writing. The review office looks at the appeal, looks at the employer submission, looks at the WCB claim file, and it renders a written decision. So all that takes place, generally speaking, without any sort of conversation whatsoever. It's all strictly done by file review. So a couple of comments, additional comments in terms of the review office process. I believe there's about 12 review officers that work at the WCB, and they're all senior staff who've been around quite a long time, most often former case managers who've worked for the WCB for a decade, if not two or more. It's an independent process, so administratively within the WCB, all the case managers and adjudicators work in one department, and the review office works separately. So they don't kind of intermingle in terms of their work. Decisions are always based on both evidence and the Workers' Compensation Act and policy. So just like the WCB's or the case manager's decision will reference all this sort of information, the WCB's review office decisions quite often are 8 to 12 pages and have a lengthy discussion about the history of the claim, relevant pieces of legislation and WSP policy, and then comes to its conclusion and provides an explanation. I put here that evidence is weighed, and so quite often there'll be competing information, right? Any sort of decision that's coming forward that's being appealed, there's people who disagree about something that's very contentious, right? So the WCB will look at and weigh information and say it will place more weight on this versus more weight on that. And so that may be, we're going to place more weight on the employer's report in terms of what happened on this date, on the date of accident, versus what the employee reported several days later, because that initial report closer to the accident is considered more valuable, more weighty. So when they're looking at weighing information, that's what they're talking about. They also decide issues on a balance of probabilities. So that what that means is when two things are almost equal, what's most likely to be the case, what's most likely to have occurred. And so when the information isn't necessarily clear, they look as a quote unquote reasonable person to the information, to the evidence, and say, in our view, most likely this is what occurred. And so something like delay in reporting an accident, they can say, well, the worker has provided a reasonable explanation. So we find that on a balance of probabilities, they did delay because they didn't think their injury was going to be that bad. It's putting some sort of clarity in something that is unclear and saying this is what we decided is more likely to be true. As I said before, it usually takes about 8 weeks, 12 weeks for a decision. The employer's involvement, any sort of further review or investigation can extend that. So 12 weeks is kind of typically the expected end for a review to occur, but it can take longer than that. One other thing that's important to know is that there is no deadline to appeal. So it can be a decision that occurred a year ago, 6 months ago, or 6 years ago. You still have the right to appeal. There's no change in your rights under the Act. But what I would suggest, if you are going to proceed with an appeal, do it as soon as possible, because the longer it takes, the less likely you're going to have a clear recollection of what's occurred. The information gets more difficult to access if there's witnesses, these sorts of things. So while there is no deadline currently under the legislation, it is important to pursue things as soon as possible. 74% of all decisions made by the review office were confirmed in 2022, and that's historically pretty consistent. Anywhere from 70 to close to 80% of decisions are confirmed in my review of the annual reports provided by the WCB. And it's kind of an interesting thing. I look back after in preparing for this presentation to see, well, how many what's their goal? And I recalled previously they actually put forward a goal and said, we're aiming to have, I think it was 75% of decisions confirmed. It may have been 80, but there was a goal. And the point is, in reading the annual report of the WCB, it actually demonstrates the level of appeal in terms of that quality assurance number. So the more decisions that are upheld, the more appeals that are denied, the better we are at the WCB, the better the WCB is in terms of making quality decisions. So the goal is to make as many appeals be rejected as possible, with the understanding that means the case managers and adjudicators are making good decisions. Of course, there's different perspectives on that, and I would suggest that a high number is not necessarily a good thing at all. But clearly there's differences in understanding of what the appeal processes means. So after the review office renders its decision, it provides it to the worker in the mail. If the claim or the appeal is favorable, the review office accepted the worker's appeal or the employer's appeal, as it were. The claim is sent back to the same adjudicator, the same case manager to implement that decision and to determine the worker's further entitlement. So quite often, as I suggested, there's an appeal on entitlement to benefits, let's say beyond October 1st, 2023. Benefits ceased on that day, the worker appealed, and then the review office accepted that, and they determined there's an entitlement to further benefits. But the review office doesn't generally say what further entitlement means. So now we're talking about, are you entitled to all of October, all of November, all of December, and all of January? Well, that's subject to the case manager or adjudicator's discretion. They have to investigate further and determine whether or not there is an entitlement. Quite often, injured workers will presume incorrectly that because they won their appeal, they're going to get paid to date. And considering that some appeals can take many months, if not years, there's no guarantee of that because we're talking about the issue in a point in time. So the WCB's decision was you're not entitled to benefits beyond this date. Anything beyond that after a successful appeal is subject to the same investigation and adjudicative processes that the WCB has. And so a successful appeal can and quite often mean another unfavorable decision that the worker disagrees with and wishes to appeal. And unfortunately, it's something that we see not infrequently. The review office isn't a final level of appeal. So if the review office makes a decision and explains its decision, but you have evidence that suggests that its decision is incorrect, you can go back to the review office without any sort of penalty or risk, have them look at that new information and review their decision. Sometimes that's very helpful if new information has come about, like an MRI or a surgical report, something that wasn't available 2 or 3 months ago when the initial appeal was filed. So that's something that injured workers can certainly choose to do if there's new information that's come to light. Alternatively, you can proceed with an appeal to the Appeal Commission, which is the final level of appeal and beyond the scope of the WCB's policy. The WCB's policy of reconsiderations only speaks to what happens internally at the review office level. So the Appeal Commission is entirely independent of the Workers' Compensation Board, and according to its website, it's considered a non-adversarial inquiry forum. And I would agree. Most injured workers who I represent at the Appeal Commission level feel that they've been heard going through the process. There may be some adversarial feelings with the employer who's also likely taking part and arguing against their appeal. But the Appeal Commission is there to listen and to learn and to make inquiries about what's the appeal is about. Appeal panels are made up of 3 commissioners, all appointed by the provincial government, and those panels are representing employers, labor, and public interest. So generally speaking, the chair of the Appeal Commission panel that hears an appeal will be a lawyer representing the public interest, and there'll be co-panel members representing employers in general and labor in general. And so it's a tripartite panel that are to be balanced in their perspective and looking at workers' compensation appeals. While the review office is all strictly done in writing and review of written material, appeals are actually done generally in person or since COVID virtually. And I would say probably 95% of appeals are done in person or virtually. You can request a file review, but the Appeal Commission decides whether or not that's appropriate. And I think that the only reason that you'd want to have a file review is if your personal perspective or information, evidence, testimony has no relevance. And that's very rare that would be the case. The only time that I would suggest that going to a file review with the Appeal Commission is a benefit rate issue when it's a calculation, and we just believe that the WCB has made an error in their calculations, and you can demonstrate that by way of paper. You don't have to be in person to show that. The Appeal Commission and panels are bound to follow the Workers' Compensation Act and WCB policy. They certainly have the right and discretion to interpret it more liberally than the WCB does, but they're still required to follow that same legislation and policy. And the Appeal Commission makes final decisions of all appeals pertaining to Workers' Compensation Board claims. So the process in terms of an appeal, similarly writing to the review office and expressing your disagreement with the WCB's process, you need to apply for a hearing either by paper or using their online system. And you're providing very basic information, similarly to the review office appeal, what the worker's name is, claim number, the date of the decision that you disagree with, and a very brief outline of why you disagree. And that will trigger the process for the Appeal Commission to schedule a date. Once again, they're going to be looking at what specific issues can we hear, because the Appeal Commission, unlike the Review Office, which can look at any decision on a claim, the Appeal Commission is limited to only reviewing decisions that have been considered and reconsidered at the Review Office level. So the legislation actually says the Appeal Commission can only look at decisions or issues that have been looked at twice by the WCB. Administrative lie by your case manager adjudicator, and then the reconsideration by the Review Office. The hearing date will be set mutually agreeable by yourself and likely your employer, and you have 5 days to present any sort of new information prior to the hearing if you want it to be considered by the panel. If you come to the panel, come to a hearing with new information in your pocket, the smoking gun, figuratively speaking, the Appeal Commission won't hear it because it doesn't allow the employer time to consider it, and it doesn't allow them for some time to consider it. So you really do need to ensure that any sort of new information is submitted to the Appeal Commission in advance. In terms of what happens at a hearing, what generally speaking happens is the chairperson will introduce themselves, they'll explain what the Appeal Commission is about, and they'll confirm the issues that are under appeal. Then they'll ask the worker, the appellant generally, for their presentation. They can either make an oral presentation, they can refer to paper documents that they provided in advance, or they can simply be there to answer questions of the panel. You don't necessarily have to make a presentation to proceed through the appeal process. As I said before, the Appeal Commission is an inquiry model, which means they're going to be asking questions. And so even if you just present yourself in person and say, I'm here because I disagree and I want to have a conversation about it, that will be sufficient in most cases. So the worker presents or is there available for questions, then the employer makes a presentation and they express their opinion on the WCB's decision. Once that's done, the panel takes over, and the panel members, each the worker representative, the employer representative, and the chair, all ask questions of both the employer and the worker and their representative, if applicable. Quite often, workers want to ask questions of the panel, but the panel isn't there to answer questions. They're there to seek answers from those parties that are pursuing an appeal. Once the questions are completed by the panel, the employer gets an opportunity to provide a closing statement, and then the worker has an opportunity to provide a closing statement. Once that's done, the hearing is adjourned, and the panel members don't actually provide a decision there and then. They adjourn and they caucus amongst the three of them. Those three panel members will have reviewed the file, and they'll have obviously heard what's taken place over the course of the hearing, but they have never had a conversation in all likelihood about the issue before them. So they'll meet the three of them and then decide if they can come to a conclusion, deciding on the appeal. And you need 2 out of 3 panel members to agree with your position for the appeal to be allowed. One thing that I should note is previously the Appeal Commission had regulations established by government that set out their rules of procedure. Now they have, under the last review of the legislation, been enabled to provide their own rules of procedure. So if you look at the Appeal Commission's website, they have a 42-page document that spells out how hearings are supposed to work and all the rules that can apply. Very technical, but frankly, Appeal Commission staff are very helpful in terms of ensuring that workers feel comfortable proceeding with the process and understanding what they're required to do. A few things to know about the Appeal Commission's process. As I said before, the WCB is not involved. Quite often, workers will believe that they are because it's the WCB that made the decision. But once it's outside the Review Office level, the Appeal Commission is looking at that completely independently, and the WCB is not involved at all. Just like the Review Office level, there's no deadline to appeal, so you can appeal 6 days or 6 years after a decision is made. Right now, it's closer to 3 months, but it can take 6 or more months to get a hearing date, depending on how many appeal hearings are being scheduled. And the Appeal Commission schedules 2 hearings a day every Monday, Tuesday, Wednesday, and Thursday. And on Friday, they are meeting to actually put together decisions. So that's a lot of hearings. And so waiting 3 to 6 months is pretty typical before you can actually get a hearing date and to argue your case. As I said, it's an inquiry model. So the appeal commission panel members are asking questions. It's not like the courtroom dramas that you see on TV, where the lawyers on one side and the lawyers on the other side are arguing about what should happen, and the judge sits back and listens. In a situation like the appeal commission, the judges, the panel members are asking questions, and it's a very active participation model. Just like the review office does have the right to look at new information, get new information, appeal commission panels do as well. And so if they've had a hearing and the 3 panel members have met and they can't decide on the issue because they feel they have missing information, they can go and subpoena that information and get that information, whether it be a witness statement, whether it be a worksite analysis, if they want to go and actually see where an accident happened, or if it's medical information that hadn't been obtained over the course of the claim. They can get it, and it's their right to do so. If they do get information after a hearing, they don't meet again with everybody involved, but they do share that new information for anybody to, for the worker, for the employer to comment on it and what it might mean in terms of their appeal. So generally speaking, decisions are made within 60 days of a hearing. Actually, that's required under the Act. But if they are getting further information, that 60-day clock stops and it starts again once they're meeting to hear the final submissions or review the final submissions on that new information. It doesn't happen often. I'd say maybe in 1 in every 10 or 15 cases that they look for new information. But then there's no deadline or no timeframes associated with that at all. So if they're looking to get information from a doctor, I had a case where the doctor moved out of province and it wasn't clear where the records stayed. They waited about 10 months before they actually got the information that they needed so that they could sit down together and make a decision on the appeal. The Appeals Commission accepted in the last couple of years an average of 33% of appeals, which is substantially better than the Review Office, especially when you keep in mind that roughly 25% of appeals are accepted at the Review Office. So fewer appeals are going to the Appeal Commission and more appeals are being accepted at that level. So generally speaking, a better place to be if you're looking at appealing a decision, but you have to go through the Review Office process first. So I kind of already covered this in a bit. The panel after the hearing will discuss the case amongst themselves. And if they find that further information is necessary to make a decision, they're going to get it and they're going to share it with you for comment. If the appeal is allowed, it goes back to the WCB to implement that decision, very much like the Review Office process, where favorable decision goes back to the same decision maker to implement. In terms of the specific process, generally speaking, it'll go through their legal department first, make sure that the legal department agrees with how the decision is looked at, and then it goes back to a manager to speak with their case manager to implement a plan. And what are we going to do to move this claim forward? As I said, though, it can take several months to get to a hearing, several months to make a decision, and that's all after the Review Office process. So it's not unusual to be 6 months or more than a year out from the decision when benefits were ended. So now it's up to the WCB to gather information to implement a decision, potentially pay benefits for an extended period of time, but not in every case. Sometimes they'll provide further benefits, not to the extent of the workers' expectations, resulting in another appeal. If the appeal is denied, I'd say in 99.99% of the cases, that decision is binding. Under the Act, there's 2 kind of exceptions to that. If the panel has made an error in law, you can request that that decision be set aside and a new panel be set to hear the case again. Or if new evidence becomes available that hadn't been available or wasn't possible to get at the time of the prior hearing, a new hearing can be arranged. Both of those are very complicated processes and take a lot of time. It's very rare to get a hearing or a decision overturned once the Appeal Commission rendered a favorable decision. Just a couple of final points before we open up for some questions. I referenced the WCB's file copy. The Review Office process is all about looking at what's on the claim file. And interestingly enough, the policy that I referenced for the reconsiderations doesn't even speak to that file existence. What I would suggest, if any injured worker is looking to appeal a decision, the first thing that they need to do is get a copy of the claim file so they can see what the doctors have written, they can see what the employers reported, and they can see the conversations that are happening between the case manager and other parties on that claim. It's very enlightening to see what's actually taking place behind the scenes. Another tip I always provide is you need to try and focus on the evidence and be an objective person in terms of the process. But if you're the injured party and you're appealing a decision on your claim, it's very easy to feel that you've been called a liar, that you've been victimized, and it's very easy to become emotional. And so it's very difficult to do. But that's why I'm suggesting if you are able to get assistance through the worker advisor office, through your union, or any sort of other party that can provide some sort of objective assistance to help you through the process. Reviewing the WCB's policies is always something that's helpful because it is subject to interpretation as well. Quite often, when we're successful in appeal, it's looking at the policy and looking at how the case managers interpreted it. And policies, words are all subject to interpretation, so they don't have meanings that are always 100% clear. And as was suggested before, the occupational health center is there, and I can tell you that I've relied on their physicians to help our members in terms of their appeal when their own physicians aren't able to provide a supportive opinion or assist through the process. So if it's a medical opinion or a medical decision that you're disputing, if you can get your doctor to back you up, or if you can see one of the doctors at the MFL Occupational Health Center, it will be very, very helpful in terms of pursuing a successful appeal. So that's all I had in terms of a presentation, but I suspect there may be a couple of questions. So I'll close this off here and see what we have.
Sure. So thank you very much, David. That was an incredible amount of information delivered in 45 minutes. And so I think that the fact that we've recorded this is going to be also very helpful, because something like this, with the issue being quite complex, be able to look back and listen to this again, I think will be very helpful. So I do personally have a few questions for you. And then I think as well, I'll send it over to Jeff to also ask a few questions. So once again, thank you. So my first question is a quick one, was when you mentioned at the end the steps that are important for injured workers to take in asking for their a copy of their WCB claim file. Can you just comment on, is there an expense to the worker for that?
Not generally. You can call the File Access Department at 204-954-4453 and request a copy of your file. And it is at no charge to you. And because the claim is a living document, you can ask for an update every week or month. As you proceed through the process, you can ask for updates to see any new information that's added. If there's an additional copy that's asked for, so if you asked for it 5 years ago and you lost it and you asked for a second copy, then they will charge you for it. And that could be anywhere from $25 for a small file to several hundred if it's a large file.
Okay, great. Good to know. And then another question, when you spoke about 33% of appeals by the Appeal Commission were accepted, are you able to speak to common reasons why appeals might not be accepted? Or
I'd like to speak to the opposite. In fact, why appeals are successful. In my view, where the review office process is all done in writing, there's no way to judge somebody's credibility whatsoever. And a lot of appeals end up being decided on how credible the worker's explanation is. And when you're at the Appeal Commission face to face having a conversation, it's very clear when somebody's evidence rings true and they sound believable. And so when I am successful in pursuing an appeal with a member at the Appeal Commission, I think it makes a world of difference to have the worker just explain what happened. And in the vast majority of cases, it just makes sense. And so that's where I think the success lies, is having that face-to-face communication.
That's actually leads me right into my last question, which is for injured workers going through this process, the need for support for them. In particular, I'm thinking about workers such as newcomers, workers whose or English isn't their primary language. Even for myself, listening to you, the really complex nature of this. So in terms of support, you did mention things like WAO and yourself, like with MGEU, and I believe like Susan Tremblay with MNU in particular. And is there, the other unions? I understand that there's probably just the two of you in terms of actual compensation specialists, but can you just speak to other unions or even non-unionized workplaces? Is the only option WAO then?
Well, I would say first off, there are other unions that do have folks that assist with appeals, but then it's kind of on the side of their desk. So they're primarily doing grievances and bargaining, but they will also help with WCB claims as well. And certainly, if somebody's there to assist you through your union, just ask, because they may have some resources to help you through that, or they may support kind of a lawyer going through the process. There are lawyers in Manitoba who specialize in workers' compensation things as well. Obviously, they cost. Yeah. If your union is able to supplement that, great. If not, and you're able to afford a lawyer, that's an option. But the Worker Advisor Office really is the best place to go, because it's free and it's objective. They're going to let you know, feelings aside, whether or not you have a case. And it's difficult to hear that they don't believe you have a case. That doesn't mean you can't appeal, but it does perhaps make you think a little bit harder on how much time you want to spend on pursuing something, and do your own cost-benefit analysis with that. And there are some other private consultants that work for workers as well. I can't speak to whether or not they're credible, but if you Google workers' compensation assistance, there are some other services out there at a cost, of course, that are available.
Yeah. Okay. Well, thank you, David. And I think I'll just send it over to Jeff for a few questions as well.
Sure. Thanks, David. I was surprised at how many questions I was writing down, and I'm like, well, I can ask you, I can ask Rob or Alan, either of our physicians, but I think you're a great person to ask given your years of experience. I also wanted to just point out we still have 40 participants. So this session is going to continue just as kind of a Q&A, and haven't been getting a lot of chats, but if you do have any questions that have come up from anything we've discussed so far, please just shoot those in. Right now, this has kind of turned into a bit of a three-way panel with the two OHNs asking questions. So I have a few here, and I put them into the Google document. They're a little wordy. But the thing that surprised me, I guess the kind of the two-edged sword here with WCB is there's no necessarily time limits on when you can appeal, but then the flip side of that is they can come back and say, oh, well, actually, maybe the original successful claim was not, like that unilateral hearing loss example that you gave. I guess that makes me a bit nervous when you start turning over these rocks with regard to what we call new evidence. And you use the term new evidence quite a bit. I know here at the OHC, we have, the medical perspective, but then you throw in other interests, right? Employers who might be wanting the WCB to reconsider a claim, for example. So that's a lot to consider, and I had questions kind of falling all out of that. But I was wondering, what are some examples of new evidence that aren't just medical, and do they tie to the employer in terms of their safety record or some other elements that might be like, oh, shoot, there's maybe a whole group of people here who were exposed to something, and now new research has evolved that's showing that chronic exposure to something is going to lead to potential disease down the road. So that's maybe a lot to untangle, but yeah, kind of that new evidence, like what are some ideas around that?
Sure. And just to back up, I mean, apologies for the presentation's technical aspect and the bulk of information that I've kind of thrown at everybody. I appreciate it. It's a lot. Appeals can be really, really simple. If it's, this is my experience, this is what's happened, and, take it as it is. And you can go through the process, and that can be as much as that's involved. But like you alluded to or suggested, that if circumstances change and the WSB starts looking at new information or new evidence arises, it can get really complicated really quick. And I don't want to suggest that, walking through this garden path and there's something there that you didn't expect. You need to expect the unexpected going through this process and be prepared to be flexible. In terms of new information, I would say half of cases that are going forward, it's medical information. It really is. So the WSB's doctor has decided or provided an opinion that says this, and the workers' doctors don't generally speak to the issue because they're not asked. And that's kind of a structural problem. I don't have an example in front of me, but the WSB's forms that they ask treating doctors to fill in are very generic, very small, and very confining. They don't ask questions like, do you believe there's a relationship between this diagnosis and the accident? They don't, virtually ever. But they ask that question of their own consultants. And so the decision is going to rely heavily on that because somebody is providing that insight. So when we're working on appeals, we're asking the doctors the same questions that the WSB is asking their medical providers. So that's generally speaking, the new information is coming from the medical system, either from a supportive doctor, physiotherapist, chiropractor, what have you, or a surgical report or an operative report, MRI diagnostics, that new information that can shed light on it. But it's not strictly medical. I would say, well, half the decisions that we're appealing is based on medical, half are based on experience and fact. So I had an accident, I hurt my knee, I continued to work, and I didn't tell anybody about it for several weeks because I thought it would get better. The evidence in that case is, did you have coworkers that knew that you were limping around? Maybe you didn't say it, but they saw you. Can you speak to anybody that can add credibility to that? Did you miss time from work? Did your employer know that you were having a hard time struggling with pain? Maybe you didn't talk about an accident. So there's these little pieces of information. They don't have to be like big written statements. Even a journal sometimes is new information that corroborates what you're saying, because quite often the assumption is anybody coming to the Workers' Compensation Board is not telling the truth. That's out there that people believe people are using the system. So what can you do to corroborate your testimony? I said at the Appeal Commission, it's quite often based on credibility. But if you can provide any information that's objective to supplement, to show that you're telling the truth, it'll be super helpful for your case.
David, I just mention that I think there might be an issue with chat for folks, and there's a reason we're not getting some questions in. And so I want to apologize for this. And I'm wondering if, and this, you had mentioned this earlier, it might be possible that folks in the audience could certainly email both myself and Jeff with any questions, and we could forward those to you. Would you be willing to do that, David?
Certainly, yeah.
And so I'll have, again, folks in the audience with any questions can email both myself and Jeff. And maybe, Jeff, I can ask you just to put our emails just in the chat for folks as well, if you're okay with that. And then folks can email us with questions as well over the next week. Did you have another question as well, Jeff? I just sure.
Yeah, I felt like that last one was a bit convoluted. Thank you, David. I am interested in the employer's kind of reasons for reconsideration. Can you maybe give some anecdotal examples of that? Or like, I'm also curious, like, which sectors of our economy do we see this happening? Is it just about getting their ratings down, their premiums down, or are these really specific about particular employers? And I know that adversarial thing can happen a bit more between the worker and the employer than even the WCB. So if maybe you could speak to that a little bit.
Absolutely. In my recent experience is strictly limited to employers that have contracts with the MGEU. So we're little limited in that, but I can say the reason most employers are not appealing, but responding to workers' appeals in a negative way is for financial reasons, 100% for financial reasons. And the problem with that is that there's no financial impact, or their participation isn't helping the workers' situation, and the workers not really understanding why. Because I would suggest the vast majority of workers don't know that their employer is paying the WCB's premiums, and so it's costing them money to be off claim. And that's the reason why, and that makes it so contentious, because the perception by most workers is my employer's appealing because they don't believe me. When in actual fact is your employer has hired a consultant because they're trying to save money. And when that perspective is understood, it really does change the dynamic for everybody involved. So I would say the vast majority is about claims costs. I would suspect in smaller employers, when I was with the worker advisor office, smaller employers would appeal based on kind of personal understandings and feelings and perceptions versus nothing to do with the finances. But with big employers, it's all about the money.
Okay, I kind of figured that, but I have one last question, and I guess maybe we'll start wrapping up here. And it has to do a little bit with recognizing the emotional aspect to all of this. Looking at the list of folks who've attended today, I could just tell by names. We've got a broad swath here, which is really great. There are situations, of course, I know no system is perfect, but when a worker feels like they have been bullied, disrespected, or harassed by anyone who's associated with WCB, like a case manager or an appeals person, what should they do? What should their response be?
Well, first off, I would suggest that they need to take it up with the case manager, supervisor, or manager. They need to be aware of that, because that's a performance issue, frankly, first and foremost. Because if they're bullying or harassing one worker, they're likely treating or mistreating all workers in the same way. And if you don't get kind of satisfaction with that conversation, escalate it to the next step, all the way up to the director if need be. I would also suggest the WCB's Fair Practices Office is a reasonable source of support. I don't think that they're there to kind of police how the WCB staff behave, but if there are issues in terms of how workers are being treated unfairly, then that's likely more of a systemic issue that they could speak to and have it addressed by the administration and the larger kind of workings within the WCB, as opposed to disciplining the case manager, for instance, right? Because that's not something the fair practices can do, but they can identify and highlight an issue that's being perpetrated against the worker for sure.
Well, sorry, I just remember one last question. Last one. And that has to do with those position statements that you mentioned that the people on staff at WCB have kind of insider access to. Well, two little mini questions here. A, can a worker or someone appealing request, like I think you kind of mentioned that maybe you could ask directly, like what aspects of policy and position statements are being included in these decisions? And second, just more generally, and this is something I can ask our doctors too, over the course of an appeal or just an investigation of this nature, if medical research, occupational health and safety research is an ongoing big area of research, and if a doctor, a community health provider, or somebody is able to turn up just maybe not even stuff specific to this worker's situation, but just more about, how myofascial pain affects some aspect of, low back pain or something. Is there a part of WCB that will take some of that in and listen, or will we ever know whether their medical people are staying on top of current research with regard to some of these? I see you kind of
I'm coughing, not laughing.
There.
That's a very difficult question to answer, because frankly and honestly, I don't believe that there's any way of kind of broadcasting new information to the WCB's medical department. The position statements, and back to the first question, the position statements are available if you know that they're being used either by asking the case manager, but more likely you'll actually have to go through their privacy office and FIPA the documents, because they're internal kind of policies that aren't meant for broader consumption.
Mm-hmm.
The way they might be helpful is, like you suggest, myofascial pain, a concussion is the biggest one that's of contention. The position statement, actually, what it does is tells the WCB's medical consultants that these are the criteria that the WCB has adopted as a whole in order to substantiate a concussion. So if you don't see these, say, 5 criteria in the medical information, then the WCB will not support the diagnosis of a concussion in relation to the injury. So what you'll see as an injured worker on your file or on a decision is that medical opinion, but you won't know that that medical opinion is being pigeonholed by that position statement. So really the best way of countering that is to talk to your own doctor and say, hey, what do you think about this opinion? And your doctor is likely going to say, well, those 5 criteria don't make sense because, like you said, there's current research that says you only need to have 3 of those criteria in order to have a concussion. So your doctor is going to be the best one to speak to that, as opposed to getting into the nitty-gritty about the position statements. But for advocates and people dealing with this on a regular basis, you need to know that they're putting influence on the medical information behind the scenes. But frankly, looking at that medical report and kind of dealing with the medical report is what you're going to need to do, because you ain't going to change the system saying it's not fair that they use a position statement, because, well, we've been doing that for years and it hasn't been effective.
Mm-hmm.
Well, David, that was just my quick question I had. So in terms of changing those position statements or advocating for a change for those position statements that are being used, what's the process for that? Or
yeah, there isn't really a process, to be honest, because they're internal documents. I think
yeah, out of our purview.
Filing a complaint with the Fair Practices Office, I think, is a reasonable thing. Saying, hey, my claim is being judged based on criteria that aren't transparent and are not accessible. If you know that one has been applied, right? That's the first step. I think that's helpful. Political action, and when we get to the next legislative review, saying, hey, the WCB needs to have more dialogue with stakeholders in developing position statements, but also policies, right? The 103 policies that exist that stipulate how the act is to be implemented is created and approved by the folks at the WCB. And they don't ask business, they don't ask labor what we think, they don't ask injured workers how these policies are going to impact them. So that, in my humble opinion, really needs to change. The WCB needs to be more transparent in how it looks at policies, how it changes policies, and it needs to have stakeholder influence to make sure that they're fair.
Yeah, and I agree. And I think part of this, just having you here today, David, is, talking about these issues. And because so much of this, workers don't understand, they don't have privy to this knowledge, even us, understanding that this position statement might be there, the steps to take. I think just having workers get more knowledge about this is critical. And I also wanted to just double check with you, David, just for folks who in the audience who are health and safety community, and correct me if I'm wrong, but David, are you presenting at the MFL Health and Safety Conference? Are you doing a session with Susan again this year? Because I did attend that and it was absolutely fantastic. So I would highly recommend, if folks in the audience are thinking about attending the MFL Health and Safety Conference. You're nodding, so I'm assuming you're going to.
February 1st and 2nd, I believe, Winnipeg, both Susan Tremblay, who's my equivalent with the Nurses Union, and myself will be presenting for 2 full days on workers' compensation. So a lot of information over the course of the last hour, but over the course of whatever it is, 14 hours or what have you, you'll be near experts in the field if you come to that presentation as well. But there'll be more jokes. I mean, I haven't been able to insert too terribly much humor in this last hour, but I promise there'll be more jokes at the MFL.
Yeah, well, it was really fantastic. I went to that last year, as you know. And then lastly, also for folks, just in this area of compensation and the issues around this topic in particular, another really good resource is just go onto our website. We have a section, Injured Worker Support. We've listed a number of resources. We're just starting that. We're just building on that. And a lot of good work happening across Canada, but specifically in Ontario with Injured Workers Online. They're doing a lot of work in this particular area with looking at WCB and the issues surrounding what we've talked about today. And lastly, I do again want to apologize. The chat being disabled, we were having some IT issues this morning. So again, both myself and Jeff, our emails are in the chat. Please reach out to us, send us your questions for David. We will forward them to David. The session here today again was recorded. And with that, again, thank you, David. And I think we're going to have you back if you can.
It would be a pleasure.
Sometime. And thank you to Jeff. And with that, I'll say goodbye, and we'll see you next time.
All right.
Absolutely.
Thank you.
Thank you.
Thanks, everyone.